Welcome to our education video on the application process and personal information. My name is Mark Fiddler, and I will provide information for all parties on the RTA's application form and discuss what the Act says about personal information. We will discuss the requirements around the collection, storage and destruction of personal information, and also look at the tenancy application process and forms. The RTA would like to advise that the information provided within this video is general advice only and is not legal advice. Please refer to the Residential Tenancies and Rooming Accommodation Act of 2008 or obtain your own independent legal advice. First, let's talk about personal information. In today's world, protecting privacy and personal documentation is important to everyone. We are asked, what is personal information? The Act refers to it as information or opinion about a specific person or someone who can be reasonably identified, whether true or not. It also covers photographs or images of someone's personal possessions or standard of living. So this could capture any photos taken during a routine inspection as well. Personal information in relation to an applicant can only be collected for the purposes of assessing the suitability of the applicant. We will have a look in a moment at the new application process and discuss what can be requested on the new application form. When collecting personal information in relation to a tenant or resident, you can only collect information if it relates to the management of the property. Practical examples of this might be the taking of photos during the tenancy. As the slide mentions, there are also requirements around storage and accessing and destruction of personal information. We will have a look at those requirements on the next slide. It is important to note that these requirements relate to both physical and digital records that may be collected and stored during an application process or throughout the management of the tenancy. As I mentioned on the previous slide, there are requirements for storing and accessing personal information, along with timeframes for the destruction of the information. The Act looks at personal information in two different areas: prospective tenant information and information for a tenant or resident who is in a tenancy. So let's look at prospective tenants first. This will include their application and personal documentation, and it must be securely stored, accessed only by the relevant person assessing suitability, and destroyed within 3 months if the applicant does not become the tenant. A prospective tenant may choose to agree in writing for a property manager or owner or a rooming provider to hold on to their application information for a longer period. For the applicant who becomes the tenant, property managers and owners have responsibilities for personal information collected during the application process and throughout the tenancy agreement. Information collected must be stored in a secure way and can only be accessed for managing the tenancy or rental premises. On the 1st of May 2025, a new requirement to destroy personal information after 7 years was introduced. This rule only applies to tenancy agreements that are active as of or commenced after the 1st of May 2025. This requirement does not apply to tenancies that ended before the 1st of May 2025, meaning that personal information from earlier agreements is not required to be destroyed immediately. Keep in mind, though, that there still are requirements under the Act for storing normal tenancy paperwork, such as tenancy agreements, entry and exit condition reports, and rent payment records. This still remains, and nothing has changed in this space, and these records must be kept for at least 1 year after the following of the end of a tenancy. The Residential Tenancies and Rooming Accommodation Act of 2008 requires a standardised application form to be used when prospective tenants or residents are applying for a property. There are two forms, one for general tenancies and movable dwellings, and this is the Form 22, and another form for rooming accommodation, and this is an R22. Property managers or owners will need to provide 2 ways to submit an application and ensure an option to submit the form is available other than using a restrictive way like an online platform hosted by someone else that is not the property manager or owner. As an example, if a manager uses an online or digital application system, you will need to ensure that you use another option or offer another option, such as a paper form or email, making it accessible to all prospective tenants. If one of the options to submit the application is an online platform, it it is the responsibility of the property manager or owner or rooming accommodation provider to ensure that the online platform is compliant with the requirements under the legislation. There are also guidelines on what information can or cannot be requested from a prospective tenant or resident during the application process, and I will step through that shortly. It is also noted here that the legislation uses some new terminology regarding a relevant lessor. In a nutshell, there's a general exemption for social, community and public housing organisations as a part of this process. This is for organisations that fall into the category of coverage under the Housing Act of 2003 or funding under the Community Services Act of 2007, or is the state or a replacement lessor under a community housing provider tenancy agreement. As I mentioned, there are two new forms, Form 22 and then the R22, which are the standardised application forms. The form includes all the questions that can be asked of the applicant, along with the ability to request documentation from the applicant to support their application. You will note the asterisk on the slide next to identity verification. Now, while the Act doesn't define or provide specific examples of an identity document, the primary purpose of the document is to verify an applicant's identity. Identity documents typically include those issued by government authorities, such as passports or driver's licenses. When verifying their identity, applicants may either provide a copy of the original identity document or allow a property manager or owner or the rooming provider to access or cite the original identity document in person. If the property manager or owner or the rooming provider cites the applicant's identity document in person, they may take notes related to the document. These may include that the document was cited, the document type, and its number. Only information that is reasonably necessary for assessing the applicant's suitability should be recorded. Handwritten notes or recording details electronically at the time of viewing the document does not count as keeping a copy. However, taking a photocopy, scan, or photograph of the original identity document is considered keeping a copy, which can only be done with the applicant's consent. And a reminder, if you seek more than the limited number of documents in each category, this can constitute a penalty under the Act. As a part of the application process, a property manager or owner cannot request directly from the tenant evidence of legal actions taken by the prospective tenant or resident, including disputes or matters considered by a tribunal, information on previous remedy breach notices, the prospective tenant or resident's history regarding rental bonds, including any claims, and any statements that detail a potential tenant or resident's credit or bank account transaction history. Now, the Act does not prevent a prospective tenant voluntarily providing extra personal information. A prospective tenant or resident may wish to volunteer further information. Additionally, the process of asking a referee for information has not changed. There is no restriction on what information can be requested from a referee, and this may include asking a referee about a past bond claim or if there's been a breach in the tenancy history. This section and requirement only relates to the information you can ask about the tenant directly from the tenant. So to summarise this process, there are two new forms, one for general tenancies and movable dwellings and a separate new form for rooming accommodation. These forms include all the information that can be requested as set out in the Act and the regulations, and provide for property managers or owners or rooming accommodation providers to request two documents from the prospective tenant to verify identity, show their financial ability to pay rent, and about their suitability as a tenant. There are sections on the forms for the managing party to fill out, as noted on the slide. These sections of the application form are where the property manager or owner or rooming provider can state which two documents they would like the prospective tenant to provide for each of the categories of identity verification, suitability of prospective tenant, and financial ability to pay rent. It also provides the managing party the opportunity to advise the tenant of the two options on how to submit the form and provide information about tenancy database checks. Again, I must remind managing parties that two options must be provided to submit and one must not be a restrictive way. And if you are using an online third-party platform, it is the managing party's responsibility to ensure the application form is compliant. And another reminder that requesting information outside what is on the forms is prohibited, but the tenant can offer more information, you just cannot request it. There is a lot of information on our website about this form or these forms and the processes, so we encourage you to check it out. And please remember, the form is to capture the information from the prospective tenant. The decision-making process is still in the hands of the property manager or owner. Thank you for listening to our video regarding personal information and the application process. Further information about what I have discussed today is available on our website at www.rta.qld.gov.au or through our other channels, including our YouTube videos and podcasts. Our friendly contact centre staff can also assist you with your tenancy or bond inquiries on 1300 366 311. To stay in touch and receive regular updates from the RTA, we encourage you to sign up for our monthly e-newsletter or follow us on LinkedIn and Instagram using the details on the screen.